What's up, everybody? Today was a day where Karen Read and her team were proving connection between the Alberts and the law enforcement officers investigating and reporting to the scene. Was it enough to start the dominoes to prove that this was a cover-up? What came out? And what are they continuing to try to do? Because they're laying the foundation to bring a lot more of this evidence in, but will the judge let them? There were multiple instances where they asked for more than what they were able to put in front of the jury, and we're going to break those down today. We're going to talk about the witnesses that testified today, and of course, as always, answer your questions. So let's jump into it. Give the video a like, and here we go. So recently, Officer McLaughlin was on the stand and they tried to get into pictures and instances where she was hanging out with somebody of the Albert family and connected to the house where all this happened at. She said they barely knew each other. It seemed like there was more, but she didn't push back. There were sometimes where it wasn't a clean sweep for the defense on her cross-examination. I thought she did an okay job. A lot of people said, oh, she's a liar. There's a lot more to this, but we're looking at what actually comes in front of the jury. Well, it turns out there may be more. It turns out they may have reason to believe that she's not telling the truth. And it turns out that the public may be getting involved in this trial. We've seen it in the Murdaugh case. We've seen it in the Take Care of Maya case. And it seems like we are seeing, we saw it in Johnny Depp, obviously. And it seems like we are seeing it here. As Stacey said, the internet said, hold my beer, because those pictures from high school or I don't know when from this officer, maybe there's more to the story. Let's hear how the day started. The very first thing the defense wanted to talk about and argue about in the first minute of court today.
Hey, good morning, Ms. Reed. All right, counsel wanted to see me?
I did, Your Honor. Judge, as I indicated in an email that I sent to your clerk last night in the Commonwealth.
I have not seen the email.
Okay, well, I'll explain what was in it. Essentially, I was alerting the court that I would like to be heard prior to the start of testimony today, because since Katie McLaughlin testified on Thursday and Friday, we received a deluge of photographs that put her with Caitlin Albert on many different occasions after they graduated high school. We received
a deluge of photographs that they received and that they've sent into the court. So doesn't this stuff have to be discovered? They didn't turn it over in discovery. They can't use it, right? Well, there are exceptions. When you just find out about something, that can be an exception. And when you let everybody know as soon as you have seen it or heard about it, but also impeachment material, because maybe you didn't know that the witness was going to tell something that you can impeach them on, something that might not be true, and that you can potentially prove that it's not true with new after discovered evidence. And many times that's appropriate to bring in new evidence to impeach something that a witness said. And that, it seems like, is what they're doing here. And Ashley said, the judge doesn't want this coming in. Well, that's interesting, because I got the same feeling that the judge was going to try to cut a lot of this stuff off, but then maybe that's not the case. So let's keep listening and kind of see how this goes and why Ashley and I may have been feeling that way because of what the judge says right here, or I should say very soon after this argument.
Received information from their high school yearbook that they were more than just acquaintances in high school. They were teammates on the track team. And even after I sent that email with the photographs that I attached to it, late last night, we received another photo where Katie McLaughlin and Caitlin Albert are standing next to each other in a photo at a baby shower in June of 2021, about 8 months before John O'Keefe's death.
So we'll take it piece by piece. Number one, being on the track team in high school, I don't think proves you're any more than acquaintances just because you're on the team together. But being together at a baby shower 8 months before this happened, and we can date that because my guess is Katie McLaughlin would not remember when that was. But the baby shower is dateable, and if we can date it, and the fact that she acted like this was not a normal thing, this was not continuing, that's pretty bad. And of course, the question, can Katie McLaughlin face charges for lying on the stand? There is a lot more to proving perjury than this, especially when she said, I don't recall a ton and we were acquaintances and none of these pictures prove that they're anything more than acquaintances. If you're trying to prove bias to a jury, that's different than trying to prove perjury charges. Okay? Intentionally lying on the stand under oath is different than not recalling or downplaying something or using the word acquaintance instead of friend or good friend. It's a little bit different, but that doesn't mean the jury can't see bias here or lack of credibility potentially, because that's something they're asked to do, is judge the credibility of every witness.
It's very clear to us that Katie McLaughlin perjured herself. And I wanted to discuss the issue of the admissibility of not only the photographs that we're now providing that we just received over the weekend, but I also want to resurrect the admissibility of H, I, J, and K for identification. And I think a discussion of this, Your Honor, needs to start with what court orders are currently in place. The leading case with regard to the provision of reciprocal discovery when the defense is offered.
So you want to get back to Rule 14, the Rule 14 issue?
It is a Rule 14 issue.
Okay,
That's
so
supplemented by-
hold on one second. So on top of that, we can discuss this later. I'd like to get the trial started.
That's fine, Your Honor. My belief, my strong belief, is that we need to determine this today. And the reason is that Caitlin Albert is coming up as a witness for the Commonwealth. She faces the same areas of cross-examination that Katie McLaughlin faced, and these photos are relevant to her cross-examination.
Okay, all right. So aside from the Rule 14 issue, I also think this is cumulative. I don't have the email. I do have the photos, but we can address.
So there's her lean that this is cumulative. I totally disagree with her, but that was the lean of the judge right off the bat, that this probably wasn't coming in. We'll see if her tune changes a little bit later. Second, I know this defense attorney said, we believe she clearly perjured herself. Easy for them to say. Of course, they're going to say it. Hyperbole doesn't matter in situations like this. The cameras are rolling. They're mad. I get it. When witnesses don't tell the truth on the stand, or you feel like they're being manipulative or hiding things, it's very frustrating as a trial lawyer. So I get it. But having a defense lawyer saying a witness perjured herself, that's a negative, hostile witness, and that he has very good documentation potentially that there's more to this angle or more context that the jury needs, that's different than a prosecutor actually filing charges for perjury, which is why we don't see it that often. I'm not saying it's impossible. I think if they can actually prove she did lie based on date ranges and pictures that they have to show what day she did see somebody or was with somebody, I think that is possible. I just don't know if that is in fact what they're going to do. John, the super chats are not automatically starring. So can you either change that setting and make sure we star them, please? Okay. So the judge says we're going to deal with this later. And so that is what we're going to do. We are going to deal with this later. Yeah. A baby shower is different than, well, depending on whose baby shower, if it's like a mutual friend again, but just being on the track team, I think maybe, I don't know if I'd let those in if I was the judge. Okay. So let's jump into testimony. First witness of the day is another officer. Again, he was told to report to 32 Fairview Road. He found the broken, clear cocktail glass with frozen blood on it. And he showed where the car was inventoried. Proctor was there. Experts inspected the car, et cetera, et cetera. The defense starts with poking a few holes in the chain of custody. And you can see the difference in the styles of the defense. Yannetti always likes to say, we've never spoken before. Jackson doesn't necessarily say that. I don't know if he has or hasn't spoken to some of these people. But we start to get into the connections. Okay. We started the first part of the trial. They were getting into the connections. Well, on cross-examination, they start getting into more connections.
Yes.
Maybe people across the street, if there were people across the street?
No, it didn't include them at the time. It included people that were involved from the prior night's incident outing, I would call it.
At the time that you tasked Sergeant Lang with this responsibility, did you know personally that you were standing on the property of Brian Albert?
I did.
Did you also know that Sergeant Lang had an ongoing and a long-time relationship with the Albert family?
Objection.
Did you know that?
I know he knew them. I think you're mischaracterizing the relationship.
Did you see a problem with?
So once again, oh gosh, sorry, this is a nightmare. So once again, did you know the Alberts? Yes. And I think you're mischaracterizing the relationship. So the witnesses try to battle back about what they know, what they like, how they feel about the Alberts, and they don't want the defense to make it seem like there's this close relationship. And something that's interesting to me too is it's not always close with any one Albert, but we're starting to learn it's a big family, lots of different, potentially powerful people in it, or people in the know, or people that know each other. And so that could affect how they're looked at throughout this process.
With having somebody who knew the parties, taking the initial statements from those parties?
I'm not at all, Sergeant Lang, no issue at all.
Not in your mind.
Not in my mind.
Were you aware that before you got to the location, Sergeant Lang had taken it upon himself to already make contact with the individuals in the house?
Objection.
I'm going to see you at sidebar, please.
All right. And there's more of it. They have a sidebar here, but don't fret. We're going to be getting to more of it. He admits that a statement in his report is incorrect. But then they start to get to the investigation, which Ashley said, biggest surprise, shock you've learned so far. So there was a couple today. And this part of the investigation was one of those couple of major shocks to me in how they gathered the evidence and preserved the evidence in this case. Because, and many of you said this on Twitter when I posted, people scrutinizing cops, and it's like, everybody's okay when, they think that the defendant's innocent, or they like the defendant. It's okay to go hard on cops. It's not okay to go hard on them in other cases. And I was just saying criminal defense attorneys should always go in and scrutinize if they see issues and ask questions and seek the truth and use cross-examination to see if these people are being honest, if they're biased, if they skipped anything, if they cut any corners. That's part of it. But even without the whole cover-up angle, a big part of today's testimony and a lot of the defense has just been, and maybe it's, and I think they're using motive for a bad investigation, that they knew the Alberts. They knew people involved, and that's why they cut corners, because they didn't want to get to the truth in this case. So let's listen to them talk about this evidence. Yes, and a lot of you are saying preservation. Here we go.
I'd like to ask you a couple of questions about the collection of the blood. You found what you thought was blood initially, right?
That's correct.
Pink in color, reddish in color.
Correct.
And you began the process of removing layers of snow, in other words, dusting the area with a leaf blower.
That's correct.
Had you ever used a leaf blower in a crime scene preservation effort?
First time.
First time. And you indicated
He's using a leaf blower. First time for that. There's a lot more firsts coming here.
your testimony was temporary evidence containers to collect that blood, correct?
Yep, we utilized cups, plastic cups.
Those were red Solo cups, right?
That's correct.
The same kind of red Solo cup you drink beer out of at a barbecue?
Yeah, sure, you could.
Objection, Your Honor. That's right.
I'll allow it.
There's nothing special about the red Solo cup?
Other than their plastic, nothing special.
And where did you get those red Solo cups?
We got them from Lieutenant Kelleher.
So in other words, you got the,
So they're using a leaf blower and red Solo cups to find and gather evidence. Just imagine that. I mean, we've seen trials where, now there's a couple things. We've seen trials where the chain of custody has been such a big deal and they have tried to say things are contaminated or not real. I mean, think about the Brian Kohberger case and all the hearings we're seeing there, over the DNA evidence, over the testing, over the preservation, everything. And then we have red Solo cups here with no caps on them, and he's going to be getting to it. This is embarrassing. This is horrible. This is not how it's supposed to be. Cover up or not, this is not how an investigation is supposed to go. Now, how important will this evidence be? I think that remains to be seen. Is it just John O'Keefe's blood? And we already knew this was John O'Keefe, and there's not an identity issue of John O'Keefe. How are they going to use this to connect Karen Reed? Those are still open questions. But if this is a big part of their case or the evidence, or this is what they relied on for the probable cause, there's no way it would have stood, in my opinion. Frankly, the defense probably loves that all this is coming in because the jury's got to be like, what? And they're going to get into it even more.
use your words, the evidence containers from a neighbor.
Correct.
He had some Solo cups in his house.
We asked him if he had any plastic containers, any type of plastic container that we could utilize.
How far were you from Kenton PD? From 34 Fairview to Kenton PD? Give me an idea.
Mile and a half.
So even in really bad weather, 4 minutes, 5 minutes? that right, to drive?
Sure.
You didn't go back to Canton PD to get actual evidence containers, correct?
We wouldn't have temporary plastic containers that what we were looking for. We're looking to take samples of snow. We wouldn't have, I know for a fact we did not have those. If we needed bags, needle containers, things of that nature, we're all set. But as far as plastic containers that we wanted to utilize, we didn't have them.
Do you have any glass containers?
No.
So Canton PD does not have or utilize evidence collection containers that are plastic?
We have needle containers that are plastic. We have blood swabs that are in plastic containers. But for what we wanted to take a sample, we did not have. So we improvised.
So we improvise, but it's like, so never in the history of this department have they ever wanted to gather anything like this? It makes no sense. I mean, I can't believe that this is true. It makes absolutely no sense. What are we doing if that is the case? And then to go to red Solo cups is like the worst option you could go to, I feel like. You could have sterilized the container or something. This stuff is important. Like, what if this was the key piece of evidence and a murderer went free because of it? And I'm sure some of you think that might be true.
My next question is, certainly Canton PD employs and owns sterile swabs.
Correct.
Sterile swab is in a container that's long, and usually the swab is connected to the lid, pop it
Correct.
out, and it's sealed
That's correct.
and forensically stable, correct?
Yes.
And the reason that it's sealed and forensically stable is so nothing can contaminate the sample, correct?
Sure.
But
Yes.
just as importantly, the blood sample can't contaminate anything else.
Correct.
So Lori,
you go-
snowstorm. But Lori, if he would have said, I mean, that's part of what he said, right? And one of the big excuses here is we couldn't see, we couldn't hear because of the snowstorm. And I've given that to the state. I'm like, everybody's not going to hear every word Karen Reed says in a snowstorm. I get it. But he said they don't have them, period. Like, they never have them, never use them. This is the first homicide investigation they've really worked on, which is wild to me too. But it's not something they usually handle, so I get it. He didn't even just blame it on the snowstorm. He's just saying, like, no, we never have something like this to use, which is just wild to me. Absolutely wild. DC said to me, there is so much reasonable doubt before the defense even presented their case. Then today, Solo cups and grocery bag next to the SUV. Are they serious? And that's the point. And if you're the defense, I think you have to, really hammer this home. And frankly, we didn't hear a lot of it in the opening. So I wonder if this is going to be a big part, or if they just have so much, you've got to pare it down and pick your highlights. Shannon said, this witness was insane to me. Couldn't believe his something, everything, Mr. Lally. Sorry, I don't know 100% what that is saying. Melanie, I'm very interested in the collection of blood evidence in Solo cups, then stored in a regular stop and save grocery bag placed close to the vehicle in question. Yeah, you have every right to be interested or even concerned in that, because there's a reason we don't do it like that. And that's because of cross-contamination and things going wrong, or things getting lost, or things getting messed up to where we can't use that evidence anymore. It's frustrating. I mean, it's really frustrating to think that this is how this investigation went and somebody's life is on the line, literally.
To Canton PD a mile away and get sterile swabs for the blood collection.
Blood was frozen. We didn't think it would be viable.
You didn't think it would be viable?
Correct.
If you
Is he a scientist? Like, they didn't even want to test. And again, snowstorm, fine. The blood was frozen. We don't think it would be viable. Are you an expert in that, sir? What the answer should have been, we took it back. We tried to swab it. It didn't work. It wasn't viable. That's what the scientist said, or the DNA forensic examiner, whatever. But to just say we didn't even do that. I mean, there's so many things they said we didn't even do. The way they gathered the evidence, they didn't go test it. They didn't search certain places or talk to certain people. She said she was saying he said he'd believe it if Lally said it, but not the defense when talking about O'Keefe's height. Right. That's a different part. Yeah, I mean, that's wild. And that's the problem, is like, at times they're not even trying to hide some of their feelings, I feel like, which could make you think, I appreciate their honesty, but also thinking, I don't know.
You touched the swab, it's a cold blood. You think you might get some blood on that swab?
I wasn't sure it would be efficient for testing.
So what you did instead was you gathered red Solo cups from a neighbor, unsterilized, and scooped up the snow with what you thought the blood was, and just carried them back to the truck?
Nope. We took 6 samples, individual samples. Our philosophy was we'll let the crime lab extract it the way they best see fit. Those 6 samples were bagged and then transported back to Camp Police Headquarters and placed into evidence.
Were they covered?
No, not that I recall.
They weren't sealed in any way?
No.
So if somebody sneezed over the top of one of those cups?
They were sealed in a bag, brown evidence bag. that time. Nobody was going to sneeze over the cup.
Um, you have a rough estimate of how many people handled those red Solo cups before they were used to collect blood evidence in this homicide case?
You want me to estimate?
I mean, I did.
Sure, side and length.
No, I mean, I'm sorry. My question was a bad one. Before you took possession of the red Solo cups, do you have any idea how many people before you had handled those Solo cups?
I took them out of a package, so probably none.
How about before they were packaged?
I assume Solo doesn't sell contaminated cups. I would say none.
So they're certainly not forensically stable. They're not sterile.
I don't know what definition you're looking for, but I would agree.
Pretty much nobody's definition are they sterile.
Do you think it's standard practice for a police department to borrow red Solo cups from a neighbor to gather evidence?
Objection.
You can go ahead and answer that,
Of
Lieutenant.
course not. Nothing about the scene was standard.
Right.
Of course not. Nothing about this scene was standard. So the question is, does a snowstorm throw out all protocols and procedures? I think it throws out some. Especially, I mean, also the snow blower or the leaf blower. It's like, is that blowing evidence around? Is that changing things or affecting the scene? It's hard. And I think when we have some technical experts, which I think we might have later in this case about police procedure, is why do you not do stuff like this? And the reason is the most important thing is, first off, taking care of the victim. Once he's in the ambulance, once he's going, then it's preserving the scene, preserving the evidence, trying to figure out what happened, who saw what, how we can handle this, because they've basically missed huge portions of that to me, huge portions of that. And when you start to miss things like that, you really have to start questioning how we're proving this and how many leaps are we having to take that the prosecution and law enforcement is not actually connecting those dots, but we're having to jump because of how the investigation went. And that's what would worry me about this case, cover up or not. The investigation is concerning here, to say the least. To say the least. He never found the missing shoe. He didn't find all the other pieces of the tail light, even though he found a clear broken glass. So that was kind of interesting to me as well. We're going to jump ahead a couple minutes.
Material anywhere else?
I did not.
You did not see any clear taillight material?
I did not.
You did not see any black plastic material? No. You certainly didn't see 45 pieces of plastic material?
I did not.
If you found a broken glass, if you find a broken glass on somebody's yard in a situation like this, did that seem out of place to you?
They were coming from a bar. It didn't seem totally out of place, no.
At the time that you
They were coming from a bar. It didn't seem totally out of place. Now, to me, it sounds like that's something that he's learned over time and kind of perfected over time. Because is that really what your first thought would be when you see a broken glass? And this gets into a great part of the cross, in my opinion, for the defense.
you found the broken glass, would you rationally think, well, maybe the rest of this glass is inside the residence?
No.
You did not think that.
No, there was a reason that I didn't think that.
Did you think that, well, let me ask you this. Did you ever go inside the house to search for the other part of the glass?
Absolutely not.
Because you made up
All
your
right, here we go. Okay. This is important. And this is another connection point. Okay. A lot of today was focused on this. Did you ever go inside to see if it matched other glasses? Absolutely not, is what he says. He doesn't say, no, he didn't think of that. He says, absolutely not. Almost feels like it was intentional, right? And that's what the defense wants to get at. To me, I wasn't even really thinking about that, if I'm being honest. And again, this is why these defense lawyers that live with these cases, all they do is try to figure out, connect dots, try to fix or answer questions, fix problems. That's what they try to do when they get these cases. So what do they think? You find a cocktail glass. Why wouldn't you check in the house, in the yard it's in? 99% of the time, if there's a glass in the yard, just take all other circumstances out. If there's a glass in a yard, it probably came from the house of the yard that it's in. But they didn't even think to check that or ask for that. They just assumed it was from the bar. I mean, that to me is really something. Mama Pinks, thank you so much for giving the step-by-step analysis, because people gift memberships all the time, and it's always a very common question on how to, in fact, accept them. I am having problems, just so you know, starring certain comments and seeing certain things come through, so I'm going to do my best to follow along. I may answer some at the end. John's going to star them and make sure we don't miss any. Little Biddle said, Peter, do you think they are used to collecting stuff in such a sloppy manner and never been questioned? I have no idea. I hope not, but this is my first experience watching this police department testify. BC, and what about the victim? I'm so sad as the investigation details come to light that this officer and his family didn't receive a professional, thorough investigation regardless of what happened. Absolutely. That's an incredibly sad part to me, because when you think about it, and they have had to go through all of this, and I'm sure they're hoping it's Karen Reed. I'm sure it feels like they think it is Karen Reed, but it's got to leave some doubt even in their mind when they go through some of this evidence and investigation and gathering and collecting. I mean, this just got to be so frustrating and sad. And that's the point of the criminal justice system, to bring justice for these victims. And so if you don't do it right, everybody loses.
Find initially where that glass came from.
Objection.
You can answer that, sir.
No,
Did you search the house for any other matching glasses?
no, no,
Matter of fact, you didn't search the house for any physical evidence, did you?
of course not.
Is that because that house belonged to-
Absolutely not, he said. They didn't go in the house. And then, of course not, they didn't search the house. So the defense is like, well, is that because it was a cop's house?
No, no,
Matter of fact, you didn't search the house for any physical evidence, did you?
of course not.
Is that because that house belonged to a Boston police officer?
No, because it requires probable cause, as you know, which we did not have.
Or at least you didn't think you had at that time?
We knew we didn't have it.
Did you seek it from a judge?
I'm familiar with what probable cause is.
Did you seek a probable cause warrant from a judge?
No, I did not.
So if you really want to be a jerk, you could have asked him, have you ever sought probable cause and not gotten it? Have you ever thought you weren't going to get it and a judge gave it to you? Because I'm sure that's happened to every cop. You don't know. And are we really supposed to believe that a cop never applies to try to get a warrant without, 100% certainty that there's going to be probable cause? No. But there's also a very big other tool that cops can use to search a house, right? As we have seen in tons of other cases where defendants get themselves in trouble all the time, because what do cops do? What do? Sometimes they just ask. And people say yes, especially if it's a cop and you trust your cop buddies.
Did you ask for consent to search the house?
We wouldn't do consent, and that's in a death investigation.
Yeah, that was my question.
No.
We wouldn't do consent in a death investigation. I wasn't following that. And again, they get into the fact that they don't have a lot of experience with this, or any experience at all potentially. But so they didn't even ask for consent. So it's like, there could be evidence in here. Let's ask, how many body cam footage and dash cam footage and how many times have we seen or heard of the cops just saying, hey, you want to talk? Will you answer some questions down at the station? Hey, can I search your car? Hey, can I search your house? If you cooperate with us, things might go easier. If we've got to go down to get a warrant, we may just flip your mattresses over and it might go crazy. They don't just ask. They try to pressure people to let them search. They try to make people feel like they have to let them search or they're going to go to jail later. And they didn't even ask. Imagine that. Imagine being somebody who has gotten screwed over, like where you're like, sure, search. And then there's some weed or something in a drawer you forgot about and you end up getting popped for possession of marijuana. Just imagine that. Or your friend has weed. Or you're a convicted felon and your friend's got a firearm in the house you didn't know about and you go to jail. That's just wild to me. Even if you would have said no to searching the house, at least as far as the investigation goes, you did your job. You did your investigation and it's not your fault. But at this point, it's more their fault than anybody else's because they didn't even ask. That's shocking to me. I mean, we're talking about shocking moments today. That's really shocking to me.
I did not.
Okay. Is that because you were at the house of a Boston police officer?
No, it's because we wouldn't do it. Because if consent is denied, we still don't have probable cause, and we still couldn't.
Because if consent is denied, we still don't have probable cause. It's like, when has that ever stopped you before? It's like, yeah, actually, we didn't chase the guy because I knew he was faster than me. And if I chase him and I don't catch him, I still don't get to arrest him. He's still faster than me. So I didn't even try to chase him. It's frustrating. It's really, really frustrating. Cheryl said, thank you for doing this. Appreciate another lawyer's input. Catching you live, Canton resident. Welcome, Cheryl. It's got to be frustrating to watch us as a Canton resident, I would guess. It's got to be so frustrating.
Search the house.
But you never asked, did you?
Never asked.
According to your interview with Lieutenant Tully, after going to the scene the first time, you then returned back to Canton Police Department, correct?
Yes,
At that point, you remember having a conversation with Chief Berkowitz, correct?
that is correct.
And you indicated that having that conversation with Chief Berkowitz, that was about Canton Police Department recusing themselves.
Not doing any further investigative interviews, yes.
And you indicated actually in that conversation that you agreed with Chief Berkowitz that Canton should be recused, correct?
He agreed with me.
Your assessment that the recusal should take place,
Yes, it was.
and he agreed.
So, right there that night, almost immediately, he thought they should be recused from at least part of the investigation. They shouldn't be the ones doing the interviews. Now, later we're going to quibble about whether it's just part of the investigation or the whole investigation. I'm not really sure why you would be recused from doing the interviews, but not recused from any other part of the investigation or gathering evidence or handling evidence or seeking evidence with the car or being there while the experts are doing things. I don't understand why you would only be recused from part of it, but even he agreed that they should be recused. They should not be doing parts of this investigation because of the appearance of a conflict.
Be recused, correct?
He agreed with me.
Your assessment that the recusal should take place,
Yes, it was.
and he agreed.
That is correct.
Okay. And the reason for that recusal was because of the relationship between the Albert family and the Canton Police Department.
No.
What was the reason for the recusal?
The reason was we had a Boston police officer on another Boston police officer's lawn, property, and that property owner was the brother of somebody in our investigative unit.
That's one way to put it. Another way to put it would be because of the Albert family having a relationship with the Canton Police Department.
It has to do with Detective Albert having a relationship with his family.
Right. Or the
Yeah, that's what he's saying. And again, he's arguing, but they're saying the same thing. They're both saying it has to do with the connection between law enforcement and the Albert family. Okay. And then they talk a little bit more about this conflict. Again, today seems to all be about connecting people, law enforcement officers, Albert family, first responders, connecting people. And if they agree right off the bat that there is some sort of conflict of interest or even an appearance of conflict of interest, how are you as the jury going to be like, oh yeah, no way, no conflict, no bias? It's like, at the very least, you have to agree there's some sort of bias there. The cops thought it immediately. And now it's become a big theory and part of the defense. Again, I didn't know this was coming, people. A lot of you guys know a lot more about this case than I did. I was trying to stay away from everything pre-trial because I didn't want to come in feeling like I knew how this was going to go. But one of the surprises to me is how forthcoming the cops are being about, yeah, we all knew that we shouldn't be handling this case. It's like, okay, great. So we're all on the same page. Except that a lot of them still did. And more of that coming later.
Okay. And then you contacted Officer Wanless to actually facilitate the removal of that light, right?
I contacted dispatch to ask Officer Wanless to return.
And you knew at the time that Officer Wanless was a sworn Canton police officer.
That's correct.
But Lieutenant Gallagher, you told us just a few minutes ago that you and the chief, actually you and the chief agreed that the Canton Police Department was completely recused from this case in the investigation based on a conflict of interest, correct?
No, you're spinning it. What I said was from participating in investigative interviews.
So
So he accuses the lawyer of spinning the conflict of interest. And again, he said we should only be recused from the investigative interviews. I don't really understand that. That would be like if I'm a judge on a case and I'm biased against the defendant. Well, I'm only going to recuse myself from talking to the defendant. I'm going to do everything else in the case. It's like, I don't think so. I don't think so.
they could take part, Canton Police Department could take part in any other part of the investigation, according to you, with the exception of investigative interviews?
We can open doors. We can facilitate things. Yes.
Remove tail lights?
There's nothing. No. Yeah. If it's an assist, round peg, round hole, absolutely. Yes.
Okay, so in other words, Canton Police Department, notwithstanding the conflict of interest, was still allowed to participate in the investigation of the Karen Reed matter.
There was no conflict of interest. I said appearance of conflict of interest. So we have to be careful. I didn't believe there was a conflict. I honestly believe we could have investigated this case, but it wasn't the appearance of such a conflict.
You also
So again, now quibbling about he doesn't think there was a conflict. He thought there was an appearance of a conflict. Well, law enforcement, judges, lots of situations where even with an appearance of conflict of interest, you should not be handling it. If you thought the appearance was so bad that you were going to recuse yourself from part of it, that's what I'm saying. You can't be forthcoming and admit it and then say it doesn't exist. That's the hard part here. That's the real hard part here.
didn't believe that it was well because Sir Topsy.
I know that.
That answer will stand. It's stricken, and so is the question.
So Canton Police Department was in fact, at your authority, given permission to manipulate that light in terms of pulling it out of the SUV, correct?
Objection.
Sustained.
Canton Police Department was allowed to facilitate the removal of that light.
Yes,
And during the course of the removal of that light, that taillight was broken, correct?
that's correct.
And shattered.
Yes.
Parts of it that were falling onto the ground.
I don't think there was anything falling on the ground at that point.
So now we do have evidence that that taillight, in some way, shape, form, or fashion, was broken or broken more once it was inside the Sallyport in Canton PD's custody.
You have to rephrase that. I don't understand the broken more part.
During the removal process, that
Mhm.
light was broken even more.
No.
Wild. Okay. He also talked about how if someone wanted to tamper with evidence, they could in the way that they gathered it and kept it in the chain of custody. There was an objection. It was sustained, but I thought it was kind of a good point. Colby asked, why is the prosecutor focusing so much on the route taken and whether for each first responder, do they have to ask every witness those questions? So, I mean, I think they're trying to lock it in, but I agree with you. It's like too much. It is important, the weather, how long it took, when the snow was gathering, what they saw when they showed up, all important. But I do think they're dragging out the background a little too much. St. Katie, it's wild how arrogant this man is, but he is showing his true colors and just comes across as incompetent at best, but actually corrupt to me. I mean, I don't know. I think that he's coming across as a know-it-all cop where it's like his way or the highway, and he knows probable cause and he knows the rules, and you're not going to tell him how to do it differently. That's more how he comes across to me personally. Melanie, is it possible that they never have any other bloody crime scene, not murder during snow? Yeah, it's possible. It's absolutely possible. Absolutely. Inquiring Mind said, leaving a bar, you never leave with a glass, unreal. So I will say, I've actually been with people that have done this. Most of them either are somebody or know somebody, right? Know the guy that owns the bar or whatever. And so they walk out without it. They know the bouncer or whatever. It happened in college. It happened out. I mean, college mostly was plastic cups, but it does happen and it can happen. It is unusual, but they know the people and he's a cop and he's leaving. It's not crazy to me to think that he could have left with a glass cup. I'm not saying he did. I'm just saying it's not crazy to me. But I would also think you'd be able to prove if that glass came from the Waterfall bar, right? I mean, this stuff should be provable. It's got to be provable, right? I mean, I don't know the answer, but I hope it's coming. I hope it's coming. All right, let's jump to redirect, which I thought was very interesting. They got into a question about why not to do just the investigative interviews. And this, again, this speaks volumes to me a bit.
Lieutenant, if I could ask you, phrase that was posed to you a couple times during cross-examination as far as recusal of your department. How would you define that term in this specific sense?
In this specific case,
Yes.
We did not want to go on any investigative interviews because one of our best investigators, his name is Kevin Albert. He's the property owner's brother.
We didn't want to go out on the investigative interviews in this case because one of our best investigators, Investigator Albert, was involved, or his family was at this property. So they knew from the jump. They knew from the jump about the connection. They recused themselves as they should. As they absolutely should. That was a great decision. That was a great move by them. I don't know why they didn't just actually recuse themselves. I mean, they admit so much here of what the defense is saying. Yeah, Vicky with a Y. So you've never asked for consent if you didn't think you had enough for a warrant? You can't say yes to that. No cop could possibly say yes to that.
And we didn't think it would be appropriate if we were on those interviews questioning his family members.
Now, with regard to death investigations, specifically unattended death investigations, what, if any, role does your department typically have when it comes to those? What, if any, jurisdiction does your department have versus the state police?
The state police takes jurisdiction. They run the investigation. We assist them in any way we can. We try to help out.
So I wonder if state police have plastic containers and stuff, or if you helping them out with the red Solo cup. I mean, how helpful really was that? Right? I mean, it's not their norm. It's not what they normally do. They've never done it, I guess, according to him, I believe, in 30 years or something. But then, so why did they do this one that way? This one this way, that one this way. You get what I'm saying? It just doesn't, I can't fathom how they made these decisions and improvised on something that they shouldn't have been handling, I guess. It's hard to wrap my mind around this one.
Now, sir, you were asked some questions in regard to, or communicated that in regard to the drinking glass that you located in the area where Mr. O'Keefe's body was, that it didn't come from the house. Why is that?
I think I said, I believe we didn't think it came from the house at that time because they were out at the Waterfall Bar and Grill the night before. And the initial statements from Detectives Sergeant Lank and Sergeant Good obtained, nobody put John O'Keefe anywhere but where he was found, and that included his girlfriend.
So it was just real clear cut, right? Everybody said the same thing. They were all at the Waterfall Bar and Grill, and then he came and he went nowhere else but this front yard. It was very clear as day. We had no other issues. We didn't have to figure anything else out. It's like if we've learned anything from these first responders and these cops, it's that nothing was clear about where he was coming from, what happened, where he was going. We didn't know if she hit him, if she hit him. We didn't know if she didn't hit him. We didn't know if she did hit him, if she hit him with a car, if she hit him with his hands. We don't know if she dropped him off there and something happened. We have heard so many different versions of this story just with the first responders that we've talked to think that he knew that this glass, this piece of evidence came from a bar and we didn't even have to like do any more investigation, to me is wild. It's really wild. So I see some people throwing legal terms. Let's take a second. Exigent circumstances, somebody asked, and somebody else said, Shy Gal said, Peter, isn't a dead body outside your house is suspicious? Isn't that enough to go in the house? So no, not necessarily. Okay. It can be, you can try to force your way in if you feel like there's any danger, things like that. I think they possibly could have gotten a warrant potentially if they had something connecting him with inside the house. Regardless, they definitely could have asked. You can always ask. There's nothing that stops a cop from asking. And again, I think that's at least doing your due diligence. I think they probably could have gotten a warrant. The guy's found in your yard. Let us go in the house and see if there's a weapon or something, a blunt force trauma to the back of the head, whatever it may be. Is any of his blood in the house? Because you can say like this evidence could go away. They could clean it. They could destroy it. It would be nice if they had some kind of testimony, but I think it's possible that they could have gotten in, but I don't think it was an exigent circumstance, never necessarily. John O'Rourke, does momentum work in an attorney's favor throughout questioning? I'm still believing the EMTs, but most people wouldn't agree. Let's hope the public opinion isn't persuading the jurors. So when you're saying believing the EMTs, there are certain things I think, absolutely I believe them on. There are certain things, side eye a little bit. There are certain things I think don't matter that they were impeached on. But what I'll say is, I believe momentum is a thing in trial. I think lawyers feel it. I think jurors feel it. I think witnesses feel it. I think the judge feels it. You get confident. You start rolling, or the other side starts to get nervous. They start to get sweaty. They start to press. They start to do too much. And that's when you can really step in it. I think momentum is a thing. I compare trial work to like professional sports, honestly. Kim R., do bars in Boston let you leave with your drink? Not places. Don't allow it and can't allow it. Seems a strange reasoning to me. And then said, good Lord, excuse the spelling errors, not wearing my glasses. So I don't know if it's a thing in Boston, but I do know it happens. I do know it happens. Creed said, I don't know if you missed it, but this is the guy who gave the info to the reconstructionist about body position, but didn't see the body before it was moved. Yes. So that was a huge part of his testimony, that he didn't see it. And even some of the people that told him where it was didn't see it. And so we're going to see how much that builds on later for how they do the reconstruction and how parts of the car hit John O'Keefe's body and prove that that's the damages and the injuries were done by the car. If it's based on this guy who didn't see him, that could be interesting. And it's all about building as witnesses come. Thinking for myself, did you see the responder that testified after the jury visit, second half day, and said, Karen Reed, could I have done this, and confirmed she was asking, not stating it? So you're saying, when you say confirmed, yes, I did see this. When you're saying confirmed, I don't know that anybody has really confirmed anything. I think we've heard a bunch of different quotes, and each person watching this trial may believe a different quote. I guarantee there are people that believe right now, sitting there, that Karen Reed said, I hit him. I think there are people that absolutely believe that Karen Reed said, is he dead? I think there are people that believe that Karen Reed was making suicidal comments. And I think there are people that believe that she said something like, could I have done this? So I don't know if anything's been confirmed, if I'm being honest. Waterfalls in Canton, not Boston. Sorry. I'm sure I'm geographically going to mess stuff up. And Gabriel said people steal glass from bars all the time. I agree. I think it happens. I think it does happen. Didn't the state troopers say not a death scene? So I'm not sure 100% what this means. Maybe somebody in the chat can help us out. I know I feel a bit of sarcasm in it. Okay. So that's it for that part. And then the defense attorney wants recross. And anytime they want recross, you should be ready because they come in hot. So here's the recross. We're just going to play about 1 minute. That blows a hole through this whole like, oh yeah, we think they were, at the bar because that's what all the witnesses said. It was so clear he was in one spot. Let's hear what the defense thinks about that.
Into their plastic containers, yes.
Thank you, sir. Nothing further.
Okay. Very briefly, you said that none of the witnesses put John O'Keefe anywhere but where he was found. That's what you just said, correct?
That's correct.
So your investigative technique is just to ask a witness, how'd that dead body get there? And if they say, I have no idea, your job's just done, right?
Objection.
Sustained.
If a witness says, we found him here, you just take the witness at their word.
Objection.
You can go ahead and answer that, sir.
No, of course not.
You might want to investigate a little further, right?
Absolutely.
And ask them questions.
That's correct.
Get search warrants.
That's-
Look
When
at
it's
the
probable
house.
cause, we do. Absolutely.
None of that was done here, though.
No probable cause.
Thanks. That's all I have.
You are all set, Lieutenant.
Thank you.
I mean, that's a win for the defense. I'm sorry. I mean, unless you just really like this guy or you really love the cops, nothing was normal or standard about this. Yes, we want to ask witnesses. You want to question witnesses. That's fair. We want to get a warrant. When we have probable cause, there was no probable cause. It's like, so you just don't do anything because you didn't think you had probable cause, and it just so happens that it's a house of a cop family. I mean, I thought it was a big win for this witness was a big win for the defense. That's my opinion. Then we had Sergeant Good, who confirmed visibility was terrible, which we saw from his dash cam. He spoke to Miss Reed. She kind of talked about her boyfriend. She doesn't really know what happened with her boyfriend. She couldn't keep a train of thought because of her state. So he kind of stopped questioning her. He spoke to Miss McCabe to try to figure out what happened. He knows Brian Albert through his brother, but they weren't really great friends. He didn't know what the inside of the house looked like. When he went inside, he looked around a little bit, but he didn't take the lead on the interviews. Everything was in order and it was a normal house. Okay. Then cross happens. And I'll show you what this witness looks like just in case you need a visual. That's this witness. And more connections made on cross. Proctor's sister was in his graduating class. One of the Alberts was in his graduating class. He's good friends with one of the Alberts. He's friends with the cop Albert. They've worked together. So how close are they? What are they willing to do for each other? Well, that's where the defense starts to dig in.
Yes,
And how long have you known Kevin Albert for?
as long as I worked at the Camp Police Department.
And that is approximately 18 years.
Coming up in 18 years, yes.
And is Kevin Albert older or younger than you or around the same age?
He's older than me.
By how many years, if you know?
I don't. Probably
Approximately? 5
5 years?
Have you ever shared a patrol car with Kevin Albert?
No,
Have you ever worked on an investigation or a case with Kevin Albert?
I probably have. Yeah.
In addition to being a colleague, would you also consider Kevin Albert to be a friend?
Yeah, we've socially hung out after work.
And because he is a fellow Canton police officer, you'd expect that he would have your back in a crisis, correct?
Objection, Your Honor.
No, I'll let him have it.
I hope he would defend me while working. Yes, he's a police officer.
You would certainly protect him in a crisis, correct?
At work, when we're police officers, yes.
Sure. Well, even out of work, if he was in a crisis, you'd probably help, correct?
I don't know what you're asking.
There's more on this later. Okay. I didn't know where this was going necessarily. I guess, sure, whatever. People, protect each other. Cops protect each other, especially at work. But it's crazy. The evidence that this defense team has. We'll see how much they're able to get into because some of it may not be relevant or admissible, but holy cow, this is not just shooting in the dark here. May sound like it, but it's not.
Well, there is the teamwork that is part and parcel of being a police officer with your fellow officers, correct?
Sure,
It's a dangerous job.
sure,
You need to have each other's back.
sure,
You need to depend on your fellow officers, correct?
sure.
And it's been said there's a brotherhood among police officers, correct?
To a fact.
And when you meet another police officer, he or she will tell you that they're, quote, on the job, correct?
Objection, Your Honor.
The objection sustained.
And in terms of, depending on your fellow officers, you're taught all this beginning in the police academy, correct?
Objection.
No, he can have that.
What am I taught?
Well, I'm asking you, with regard to the teamwork and, having each other's backs and, working together and depending on each other, you're taught that starting in,
Sure.
and it's reinforced.
And I don't think that's like a bad thing or a big deal. And again, the defense is not pushing it too much right now. They're just pointing out things that are facts. And again, this makes me think maybe they're going to have a police instructor type of an expert come and talk about what they teach in the police academy. I don't know. Michael said, public defender here. Sorry, Peter, can't agree. Dead body found on the property is easily probable cause. That's fine. I would say arguably probable cause. If you want to say easily probable cause, this officer says no shot at probable cause. Definitely something I think they would apply for a warrant for. I tend to more agree with you that I think they would get the ability to search this house. And probably an emergency warrant because, again, the evidence could be destroyed, it could be covered up, it could be removed, whatever it may be.
Forced over the years by superior officers and your colleagues, correct?
Sure.
Now, you were assigned as the
This cop also knew that they recused themselves that day. Okay, literally that day. He also said they never handle homicide, so that was confirmed as well. And then I thought he was going to score some points on the defense, and there was a bit of a zinger, and it kind of ended up being a tie, but he's like, no. I had 34 Fairview in my report. And so I did think this was a little bit of a hurt to the defense if the jury is paying really close attention, because they said like 34 Fairview was nowhere in any of the reports. It was all covered up because it was an Albert house. Well, here it is. And maybe they didn't say it so, matter-of-factly out of everything, but that's what it felt like to me, and I thought it was a really huge point. But turns out 34 Fairview did make its way into at least one report. So let's hear this back and forth.
phone such that you can actually see the location on a map, correct?
Sure. Yes.
And you would agree with me that ultimately when the location was entered into your system, the location was entered as 32 Fairview, correct?
No, it was 34. At least we put it out as 34.
34 was the actual address, but 32 is what made it into the police report, sir, did it not?
No, my police report says 34 Fairview.
I'll say 34 or 32. Here we go. Defense attorneys have been very prepared, so I was surprised. I was like, oh man, did they miss one here?
Now, when that call came in after 6 a.m., you decided that you would personally go out, correct?
Yes.
Which was interesting because he was like the one taking the calls and stuff, and he decided to go out and get a replacement for him to do that. So is he pressing to make sure he got there to help out his buddy? I'm sure that's going to be an argument the defense makes.
Okay. I actually have the front page of your police report. May I approach, Your Honor?
Yes. Show Mr. Lally.
I'd ask you to read that silently to yourself, take a good look at it, and look up at me when you're done. Getting back to the location, which you said was important, what is the location listed in your very police report?
On the face sheet, it says 32, but in my narrative, it's 34.
The face sheet is important, is it not?
Yes.
People see the face sheet before they get to the narrative, correct?
Sure.
Is accuracy important?
Yes.
And the very first thing that's entered with regard to the location is inaccurate, right?
Say it again.
The very first entry with regard to the location on your police report on the face sheet is inaccurate. Would you agree with that?
I guess so. Yes.
And with regard to
So again, that was a little bit of a push there, a little bit of a push. He had 34 in his narrative, didn't have it on the face sheet. So again, somebody did have the right, address there. So I think it's harder to say that this guy was trying to cover up the address since he in fact did at least put it in his narrative, which is the part he probably controls a little bit more. But he decided also not to try to search certain things, even when he was allowed to go inside the house.
when the police went in the house, you were there with Sergeant Lang.
Yes.
All right. And when you went in, can I have Exhibit 8 on the screen, please? Terrific. You're able to see Exhibit 8?
Yes.
Is that a fair depiction of what the house looked like when you entered it?
Yes.
Did you see the front door?
Yes.
Is that the door that you entered?
Yes.
And you had testified that you looked around the immediate area where you were while Sergeant Lenk was asking questions. You noticed that when you entered that front door, you come into a foyer area, and directly in front of you on the left, you can almost reach out and touch. There's a door that goes down to the cellar. Is there not?
I don't know. I don't remember a door there. I remember the stairs going up to the second floor.
I see. So you don't remember that as you step into the house, you can go down a cellar door right away.
Objection.
No, I don't know where the cellar is.
The objection sustained.
You don't know where the cellar is, and that's in part because you did not go down to the cellar, correct?
Correct.
You never examined it?
No.
You never saw what condition it was in?
No.
You saw whether there was any signs of struggle down there?
No.
You never saw if anything was tipped over?
No.
You never saw whether there was any blood or other trace evidence down there?
Objection, Your Honor.
The objection sustained. You've made your point. Can we turn the lights back on?
So he's hammered it so much that the judge makes a comment like, you've made your point. They didn't search it. They didn't even try. They weren't looking for anything. That's clear. It's so clear. The judge is like, just chill. Which brings me to this question. Peter, what are your thoughts on the judge? I'm torn. I don't have a huge problem so far. I don't love the, you don't give a reasoning for your objection. I don't love that. I know some people think that she's unfair to the defense. I think she's given the defense plenty. Now, I don't hear the sidebar, so I don't know what she's cutting them off there, but I think she's giving them decent leeway, and I think she's about to give them some more. We're going to listen to the argument later about the proffer or the voir dire of a witness to see whether or not they're going to be able to get into some stuff. And if she lets them get into it, I mean, if she was really horrible and biased, she could find a way to not allow a lot of this stuff in, and some of it is coming in. Ken said, isn't an objection supposed to be followed by a reason for it? Lally object, Aunt Bev usually automatically sustains. I don't know who Aunt Bev is. I guess, is that what you're calling the judge? So from the jump of the trial, she said she doesn't want any reasoning, no speaking objection. So it's just objection. She basically runs through her head all the reasons for the objection. And if she can find one, she says sustained. It's wild. I don't love it. I think it's going to have appellate issues potentially. But we'll see. John said, will there be an accident crime scene expert movement specialist similar to Gwyneth Paltrow's ski trial? That would be huge and a game changer. Yeah, like a body mechanics expert or biomechanical expert or whatever they call it, reconstructing this accident, seeing how the body moves. I hope so, but obviously I don't know. I haven't studied the witness list. Carrie said, if a witness has proffered with the feds, what happens when he gets on the stand? Does the judge just dismiss the case? If a witness is proffered with the feds, what happens when he gets on the stand? Does the judge just dismiss the case? I don't think these words are used correctly in this sentence. So a proffer is just an offer of proof where you say in front of the judge what you expect to come out in testimony. So a proffer with the feds, if you go do a proffer with the feds, there's a bunch of different reasons. You can tell them what you would testify to. You can talk about what you can do to help the case. Does the judge just dismiss the case? That's the part I'm not understanding, is the judge just dismissing the case. Sorry, Carrie. Malik, I watched a lot of this witness earlier, and I noticed a shift in his demeanor when it was time for cross. Does that happen a lot? Yes. Happens a ton with witnesses, especially experts or law enforcement. Sometimes they can't help themselves, and their body language really, really changes. Kathy said, how can they charge her for drunk driving when they didn't even see her the night prior? So different rules at different states. In Florida, you need more than just a statement from the defendant. Somebody's got to put you behind the wheel, things like that. So I don't know yet. Let's wait and see how the evidence comes out before we get there, and I'll try to read through what they need to prove there. Officer John O'Keefe wasn't pronounced dead then/yet. MSP wouldn't respond, intervene because of that. Okay, so the state police wouldn't come because he was not pronounced dead at the scene. That makes total sense. Got it. Get it. Thank you for clearing that up, Cheryl. And then as this goes to the probable cause argument, somebody almost dead in the yard probably doesn't change the probable cause argument that much, but I do think that's a good point. That's why they didn't show up, and that's why this was left in the hands of these officers. Thank you for pointing that out. Okay, he said Karen Reed was distressed. Never heard her say, I hit him. Agrees they didn't follow proper protocols. They spelled out everybody's name in the report but Brian Albert. But we get to Officer Lenk. Sleuthy said Lenk wasn't on duty either. And you heard he was the one that would go in and question some of the people and get some answers from some witnesses and do the job. at the Alberts house. Go in and talk to all of them connected there. And that's the one that he was talking about with the officer prior to this, that Lank should have been doing this. You knew that. You guys knew that this was an appearance of a conflict and that there were issues and you were recused. So why would you ever let him go in and work this case when he wasn't even supposed to be on duty? And so they bring him up. They talk about, so what they do is they end for the day after this witness. Actually, this witness isn't even done. But they end for the day and they bring this guy, Officer Lank. And the purpose of this is the defense wants to get into his bias, his background, his connections. Again, it's a day of connections. His connections to the Albert family. My guess is the internet is out there looking for more connections. So they brought him in to voir dire him, proffer, whatever you want to call it at this point. They called it voir dire, I believe, to figure out what he's going to say. And the judge is going to make a call if some, none, or all of the evidence of bias that the defense wants to get into is going to come in. And I will tell you, this sounds like a horrible, dirty cop movie. I cannot believe I know you guys are not going to feel bad for him. I feel a little bit bad having this aired out because it was a civil lawsuit that he settled, technically confidential. It doesn't mean he did anything wrong just because he settled the civil lawsuit. But oh boy, does it sound like there's a bunch of smoke around these allegations that we are about to hear against this officer who was importantly involved in this case. So he agrees that he's got connections to the Alberts. He's known them all since childhood. Specifically, Chris and he were close. He denies being drinking buddies, but there's some context that maybe sounds like they were drinking buddies. And now we are going to get into an absolutely wild story. And Sleuthy said before that Lank wasn't on duty when he came and got involved in this case. Well, guess what? That didn't stop him before. And again, I'm not calling them dirty cops. I'm not saying that's been proven. I'm just saying this sounds like the plot of a dirty cop movie. All right, let's hear it.
I was.
At some point, did you realize that Chris was
Story that happened 22 years ago with he and Chris Albert, okay? They're at a bar. He's in his car, his personal vehicle. Chris Albert's inside, and stuff happens.
getting into some sort of physical altercation with somebody else in the parking lot?
Yes.
Did you jump in?
I don't know where he was.
Were you at a bar?
I was.
At some point, did you realize that Chris was getting into some sort of physical altercation with somebody else in the parking lot?
Yes.
Did you jump in into a fist fight in order to protect Chris Albert?
Chris actually approached my vehicle and started to describe an altercation that he had been in previously in the night.
When you say your vehicle, your personal vehicle?
Yes.
Okay, so you were off duty, is that right?
Yes.
You've been drinking?
Yes.
Nothing wrong with that, but just
Yes.
what happens is you've been drinking that afternoon.
Yes.
Tim Albert was with Chris, correct?
Not when I saw him, no.
Ultimately, when you realized that Chris Albert was in some sort of fracas, some sort of fight or altercation, you activated yourself as a police officer at the time.
He wasn't in a fracas when he approached my vehicle. He approached my vehicle and stated that he had been in an altercation earlier in the night with one of the Lapalato brothers, and that during that altercation, threats were made against him and his family, and he was seeking advice because he knew as a police officer as to how he should go forward. And as I was
So he tries to put some context on it, tries to make it sound not that bad. But the defense attorney's like, you became Mr. Cop, even though you were out, not on duty, personal vehicle, and you had been drinking, but then you became Mr. Cop to help out the Alberts, right?
telling him what to do, that's when a group of men started to walk down Washington Street towards Chris, and he said, "Oh no, here they come."
So that would be Mark Lapalato, correct?
Yes.
And his brother Alfred.
Yes. Alfredo.
Alfredo, sorry. You got out of your car and approached the other men.
Yes.
You also called for a Canton police backup.
I brought my attention to the restaurant owner and a bartender who had walked out into the street, and I yelled for them to call the Canton police.
Canton police did in fact arrive, correct?
They did.
So he says he's an officer. He gets out of his vehicle. He approaches the brothers that are fighting with Chris Albert. He tells other people to call for backup and call Canton police, and they show up. Imagine me and these other two guys. You think you're getting in a bar fight, and then whoops, pick the wrong guy.
Is it true that after you got involved and Canton police arrived, you then
Not that you should get in a bar fight, bad things happen. This is an example of why you shouldn't get in bar fights, because you never know who it is you're fighting with. It could be somebody carrying a weapon. It could be somebody that gets the whole police there to, ruin your life, basically. But listen to what happens.
instructed some of your colleague police officers to handcuff Alfredo?
I can't recall.
Is it true that after Alfredo was handcuffed and for all intents and purposes, physically incapacitated, you then approached Mark Lopalotto.
No.
You got into a fight with Mark Lopalotto.
Yes.
You punched him in the face.
At one point after he had struck me, yes.
So your story is he struck you first, and then you punched him.
Yes.
His story, of course, is you punched him first.
I don't know what his story is.
Well, you were sued.
So they handcuff one of them. Cops are there. Just picture yourself the scene. Cops are there. There's a bunch of them. There's backup. There's this cop. You were fighting with somebody connected to the cops. Your brother's handcuffed and another cop punches you. Now, his story is that the brother involved in the fight punched him first, which that seems plausible. A bunch of cops around that you're just going to punch a cop when your brother's already physically incapacitated or in handcuffs. That's wild to me.
In federal court, and he told you the story in that lawsuit, correct?
So he said there, I might have missed it. He sued you in federal court.
I don't know what his story is.
Well, you were sued in federal court, and he told you the story in that lawsuit, correct?
So I actually have a question. The criminal case was adjudicated. The civil case, I did sign a non-disclosure, so I'm not sure if I can speak on that.
I will never ask you what the nature of any settlement within that case was. Just the fact that you were sued in a public document, which a federal lawsuit is a public document. You were sued in federal court over this incident that I'm talking about, correct?
Yes,
And ultimately, it was settled. I'll never ask you what the terms of the settlement are.
it was settled, yes.
Okay. Ultimately,
And so why is this coming in? If it's hearsay, again, we don't know that it's all going to come in, but there are ways it can come in. He just said he doesn't know his story, which is not true. His story was in a lawsuit, so it can be used for impeachment purposes, and it is not necessarily being used for the truth of the matter. Of course it is, right? Of course the defense is trying to use it to say this cop punched the other guy first, not the other way around. But for argument's sake, it's more of, it doesn't really matter. It doesn't really matter if it's true or not. The fact is, it's a he said, she said. You said you didn't know his story. Here's his story. Whether or not it's true, this is his story. Sorry, we're pushing our Chad Daybell video back 10 minutes so I can fully dig into this.
you said that the criminal case was adjudicated. We'll get to that in just a second. Did you testify at that criminal case?
I did.
All right. I want to sort of tailor this a little bit because we're on a little bit of a time crunch and I want to be sensitive to the court's time and your time. The allegation that Mark Lopalotto made against you is that you punched him, took him to the ground, continued to beat him, and bit him to the point of drawing blood, correct?
I believe that was his allegation, yes.
So his allegation is you beat the crap out of him with all your cop buddies around, with his brother handcuffed. That's how you did it. And then we heard he settled. So, of course, what do you guys think that means that he settled, right? I know it's actually true. I feel that. Sometimes I got to see a lot more before I get my mind, but usually the general public takes that as an admission of guilt, whether or not it's true. So if the jury heard that, yikes.
It indicated that once the police officers that were there pulled you off of him, you then turned and walked over to Alfredo while he was still incapacitated, meaning physically handcuffed, and spat in his face.
I believe that was his allegation, yes.
Ultimately, both men, after this altercation, were allowed to leave the location, correct?
I believe one fled and the other one was allowed to leave, yes.
Okay. You're telling me now that Mark Lopalotto punched you first, the police officer, correct?
Yes.
And are you aware of any circumstance in which an individual would be able to punch a police officer on duty or off duty in the presence of other police officers and just be released? That wouldn't happen.
I don't believe the other police officers were on scene when the fight initiated.
Did you tell them that you got punched?
I don't recall.
They certainly
So
let.
now he's saying the cops weren't there when he got punched, and this guy was allowed to leave after punching a cop in these circumstances. I don't think so. Just to be clear, this is not happening in front of the jury if you guys didn't watch this today. So very interesting. Francis said, what does for the truth of the matter asserted mean? So for the truth of what you're saying or trying to get into. So again, in this situation, the fact that the other guy said he punched him first, we're not trying to use that to prove he punched him first. We're just trying to prove you, Mr. Officer, you know what the guy's story is. You know what the other guy's story is. Whether his story is true or not, we can prove you know what it is because he wrote it right here in this lawsuit that you punched him first. You know that's his story, regardless of if not if it's true. So that's not using it for the truth. But if a fact I need to prove in a trial is that that guy, is that you punched that guy first, then using his out-of-court statement to prove that he punched him, that would be used for the truth of the matter asserted. Sorry if that's confusing. I'm sure there's a better example, but I like to use the examples we're dealing with. Misty said sterile urine cups would have been better. I mean, I can think of a lot of things that would have been better, honestly. M. Cray. Peter, I'm behind, but want to ask, how can anyone get past solo cups for evidence collection? And when he was pronounced dead, why didn't the state police take over then? I don't know the answer to the second part. The first part, if that's not the major connection or piece that was the reason Karen Reed was indicted or arrested or probable cause or anything like that, that's potentially why. It's still going to be something the defense attorneys obviously can poke holes into and use for credibility, and that it was a shoddy investigation and things like that. And that's just kind of how it's going. Basically, the materiality. How material was that screw up? And I guess not enough to get the case thrown out.
Mark go, correct?
Mark fled.
Okay. Now,
Alfredo was released.
so the next day, Mark and Alfredo showed up at Canton PD to file a complaint against you and some of the other police officers that were involved, correct?
That's what I was told. I wasn't there.
You didn't file a report for assault, battery, or anything like that, correct?
I spoke with my sergeant that night, and he said that I could do the report when I came back into my next day of work.
My question is, on that night, did you file a report?
No.
The next day, did you file a report?
I don't recall if it was 1 or 2 days later.
It's actually 3 days later, wasn't it?
I'm not sure.
Does it sound like that's in the time frame? Probably was about 3 days later.
I honestly couldn't tell you. It's 22 years ago. I'm not really sure.
But between the time this fight happened and you filed a report, Mark Lopolito and his brother Alfredo came into Canton PD and asked to swear out a complaint against you and fellow officers, correct?
I believe so.
And they were told to go
So the brothers come and they want to make a complaint against this officer. And what happens?
away on that day.
I couldn't speak to that.
By the time they came back to file the complaint, then police reports had been written, right?
I don't know.
They are sent away when they try to make their complaint. And by the time they come back to make a complaint, now there have been police reports filed against them days later. So he didn't file a report against them right away. He waited days. He admitted that. And, you know, paperwork stuff takes time. If you got punched by a guy like this, you probably would have filed a report right away. They didn't. The guys come to make a complaint. They send them away. Then they file the report. So when they come back, there's already a police report. So they look like, I don't know if you know about this, but if a criminal defendant comes and he already has charges against him, and then he says, oh, well, the cop hit me first, it's a lot less credible than if he comes first as the victim and says the cop hit me, and then the cop filed charges. Then it seems like retaliation. This is, if this stuff is true, this is abuse of power. This is dirty cop. This is exactly what we don't want. This is pretty much what the defense is claiming happened in this case. This is horrible. This is really not how it should work. I feel terrible about this. I really, really feel terrible about this.
Once those police reports were written, after they indicated that they wanted to file a complaint, ultimately charges were brought against them, correct?
Again, ultimately charges were brought. I don't know the exact timeline.
After charges had been brought, and both brothers ended up having to go to court and defend themselves, you ran into both brothers at a mobile gas station.
Yes.
You confronted both brothers, correct?
No.
So hold on. So we've got the open criminal case against the two brothers. They have to defend themselves now. And this guy sees them at a gas station. Okay, so if these guys try to beat you up or punch you in the past, what are you going to do? I'm just walking the other way. I don't want anything to do with this, right? Well, that's not what this cop did. Let's talk about what he did.
Into both brothers at a mobile gas station.
Yes.
You confronted both brothers, correct?
No.
You approached both brothers.
No.
Isn't it true that you walked up and said, how you doing, to the two guys? And one of them responded, not so good. You attacked me and now I've got to go to court.
No,
That conversation?
I believe they initiated the conversation with me.
Did you say, how are you doing?
Something to that nature.
And did they respond? Something to the effect of, I'm not doing so good because you attacked me and now I've got to defend myself in court.
I don't recall exactly what they said in response.
And then, based on that interaction, you arrested them for witness intimidation, correct?
You heard that right. He goes up to them or they come up to him, whatever it is, how you doing? They respond with something and he arrests them for witness intimidation. I mean, literally, I'm trying to think of what movie this reminds me of, but I swear it's like the movie where the cops are like, well, I can arrest you for this. I'll arrest you right now. I am the law, right? I do what I want. I arrest who I want. Everybody believes me. I'll have all my boys here right now. We'll handcuff you and beat you up. That's what this sounds like. This is horrible. Like, this sucks. This is why everybody needs to be held in check. Cops, lawyers, judges, doctors, everybody needs to be held in check. You don't just believe somebody because they say or do something. That's why we have the legal system where this stuff has to be proven beyond a reasonable doubt. Because if people just believed everything cops said or any witness said, look at what the world would be like in certain areas. I mean, this is horrible. Horrible. A little bit of training day. I feel a little bit of training day in this, but I see somebody saying The Departed. Yeah, training day. Yeah. That's, I think, the vibe I'm getting, which is not a good one.
Well, there was further interaction. It wasn't just a response to how are you doing. They made threats and they were ultimately arrested. Yes.
So your claim now is that they made threats against you, a sitting police officer at the time, a working police officer.
Yes.
Okay. And you reported that threat to the DA's office.
Yes.
And charges were brought against them. I'm sorry. A report was brought against them for that witness intimidation, correct?
Correct.
Ultimately, with regard to the assault charges for which they were arrested and tried, they were found not guilty in a public adjudication criminal case, correct?
Correct.
And the DA's office threw out the witness intimidation charges because they were meritless. Isn't that right?
The
Hold
For
on,
which they were
back that
arrested,
up.
witness intimidation, correct?
correct.
Ultimately, with regard to the assault charges for which they were arrested and tried, they were found not guilty in a public adjudication criminal case, correct?
Correct.
And the DA
So the assault charges for hitting this guy, they were found not guilty. And if that wasn't bad enough, the DA threw out the witness intimidation charges. Now, number one, they could have thrown out the witness intimidation charges because they lost the assault case. Or number two, they just didn't feel like they had enough evidence. And sure, you got arrested, but then they threw the charges out, which is also why somebody getting arrested for something does not mean they did it. It does not mean they are guilty. We should not just convict people because they are arrested for something. We shouldn't hold arrests against people as if they're the same thing as convictions. Because number one, people fight arrests and win all the time. Charges get dropped or not brought, or cops can arrest you for basically anything. And then it goes on your record. And if you don't get it sealed or you don't get it taken off, there you go. Every job you apply for is you're going to have to check, yes, I've been arrested.
DA's office threw out the witness intimidation charges because they were meritless. Isn't that right?
The charges were thrown out.
And all of this history that we just talked about came on the heels of you assisting Chris and Tim Albert in a fight they said they'd been in earlier in the evening. Is that right?
No.
You just told us that the reason you got involved in this melee, this fight to begin with, was because Chris Albert approached you and said, I was in a fight with some guys earlier tonight, and here they come.
Yes. And you just said that he was with Tim Albert. I never saw Tim Albert that night.
My mistake. Let's just leave it at
He was with his fiance.
Okay. So all of this situation emanated from you coming to the aid of Chris Albert, your friend, longtime childhood friend, correct?
It had nothing to do with it being Chris Albert.
Isn't it true that it had everything to do with it being Chris Albert?
No.
So just a regular random guy off the street, you would have conducted yourself the exact same way.
Absolutely.
What? Talk about momentum, John. I kind of feel like they were just rolling, and this guy was like, okay, I got to argue with everything the lawyer's going to ask. No, it's not about Chris Albert. It's not just about Chris Albert. It's not just about Chris Albert. So you would have just done this for anybody. Absolutely was his answer. Absolutely. So this guy has been drinking at a bar, and he's sitting in his personal vehicle. And if John Smith comes out and is like, hey, bud, knock, knock, knock. Can you come help me? These two guys are fighting with me. And this guy's going to get out of the car, get all the cops there, get in a physical fight with one of the two people, make sure charges are brought against them, all for just a random guy. Come on. Come on. That's crazy. I mean, that's crazy. All right. Then there was another situation where Albert hit a car. Maybe there was some suspicion of DUI, but they did no real investigation. He was charged with a misdemeanor, did diversion program, which is basically just some courses and some community service, and then his record was wiped clean. Then we get to the arguments. The argument is basically the defense says we have to prove that there could be bias and prejudice, not that there is beyond a reasonable doubt. And they said 22 years ago, because sometimes how remote something is makes it less relevant and less reliable. But in this situation, the defense says it's actually good for us because it shows the long-lasting, long-standing relationship between cops and the Alberts and how they've protected them for 20 plus years. So they actually think the 22 years is a good thing. Also, this cop was engaged in a series of interviews that weren't recorded. So all we have is his word and his testimony. And the jury needs to remember or realize what this guy is willing to do for the Alberts. That's what the defense argues. And we'll play just a very little bit of this because the video is running long here tonight.
For him to sort of deputize himself in that situation in order to help out his longtime friend, whom he socializes with, drinks with, grew up with, establishes a bias and a prejudice, in this case against Miss Reed, and in favor of the Alberts. And it's not like he had a tangential part to play in this, a role to play in this investigation. He was the very first officer to walk in that front door. He absolutely knew what he was going to find when he walked in the front door, which was the homeowners and possibly other witnesses. He engaged in a interview or a series of interviews that were not recorded. I have no idea what was said. The jurors are never going to find out exactly what was said other than to take his word for it. The jurors have to be able to weigh and balance his credibility against an officer that, for instance, even like Sergeant Good, for instance, who seems to come across far more unbiased, just sort of a straight shooter. Sergeant Blank is not that person. He never should have walked in that front door. He should have said to his supervisors.
So he even offers that agrees that some of these officers are straight shooters, but not this guy. Not this guy. And the jury needs to know that.
I have a relationship with the Albert family. I've known these folks for too long. I grew up with his brother or brothers. I've known them my whole life. I'm probably not the right person to make the decisions about this investigation. And unless and until the jurors know that and can weigh and balance it, they can toss it out if they want to, or they can adopt it if they want to,
So-
if they need to be able to hear the evidence.
So I have a question for you. So the part about the complaint at the station
Yes.
and being turned away, who are you going to get that in from other than the Lapolito brothers, which puts us a little far afield? So he didn't adopt it.
So the judge makes a good point. How are we going to get into all this? Are you going to call the Lapolito brothers? Because are we going to have a trial within a trial here? How do you plan to do this?
Or said, I don't know, or that's what I've heard.
So the Lopolito brothers, I think.
I know, but that's so far removed now.
I disagree. I think they're the ones that are closest to the situation. So we would ask who's better to tell the jurors that they walked in. I can get the police report. I can tell the court when it's dated. It's dated September 2nd or September 3rd, and the Lopolitos walked in on August 31st to make the complaint.
No, I understand because you've outlined it, or Ms. Little outlined it, which is very helpful. I don't disagree that some of this is admissible. I just have to figure out how you intend to get it in because I have to be concerned about.
Did you hear the judge? She doesn't disagree that some of this is admissible. So we're going to get at least some of this in front of the jury.
No, I understand because you've outlined it, or Ms. Little outlined it, which is very helpful. I don't disagree that some of this is admissible. I just have to figure out how you intend to get it in because I have to be concerned about if it's a mini trial within a trial, and we're trying to avoid that. If he were to testify as he did, that's what I understand, and the Commonwealth didn't object to that. That seems admissible to me.
I would probably seek to do it with the court's permission through two pieces of evidence. One would be Mark or Alfredo, and I don't think I would use both of them.
You would not.
I would not. Okay, fair enough. I would seek to ask Mark to join us. He would testify to the altercation. He would testify to the complaint, and then I would seek to either get a stipulation to the date of the police reports. I don't even need the police reports in. If I can't get a stipulation, then I probably would just ask the court to be able to establish that the police report is a business record.
So I would like to see those police reports tonight before I leave. Okay.
If I have them.
You'd have to get them.
Right. I will do my best to get them to the court. I can't get them to the court tonight. We don't have them.
Okay.
So I'll start working on that immediately.
All right. Anything else?
No, Your Honor.
Okay, Mr. Lally.
Basically, Mr. Lally's best argument is that the defense exaggerated Lank's involvement in the case. And it sounds like maybe he just did those initial interviews. I don't have a ton of time to blow through it tonight because, as some of you are asking, Barbara Bell, a bunch of us needed you today during the Daybell trial. Well, that's what's about to come up. But before we get there, I'm going to burn through some questions. I can't wait to see what the judge lets in. Cam said, I don't have it to put up here on the screen. Sorry, because my starring of my comments was getting screwed up today. Alaska v. Davis clearly states some of the evidence the judge, oh, there we go. Thank you, John. Has not allowed or somewhat allowed is clearly admissible when it goes to bias. I think the judge is going to let it in. Let's wait and see what she lets in. And then we can say, I agree, I disagree, whatever it may be. We can have that conversation after. Candidly, Kristen, this case is riddled with distractions. Did police mess up the investigation? Are injuries consistent with being hit by a car? Car damage from hitting John O'Keefe? If yes, to any of the above, reasonable doubt. Car damage from hitting John O'Keefe, I don't know if that would create reasonable doubt. If they're consistent, maybe if no to any, I don't really know. I think there's a lot. There's a lot still to answer. And a bunch of people were asking, what's your lean? Are you leaning guilty or not guilty? I don't have one yet. I want to see the rest of the evidence. I'm holding pat right now. I have not made up my mind. Nobody should make up their mind yet. I know a lot of you know a lot more than I do, but from this trial, there's still a long way to go. It's a marathon, not a sprint. Mary Claire, Peter, I'm struggling to connect a 20-year-old bar fight with a court settlement relates to what happened to the night Officer O'Keefe died. Is it simply to smear the witness? My honest opinion, Mary Claire, this is so outlandish and unbelievable. And I'll tell you right now, if this was somebody on trial and they had such a similar bad act in their past, even 20 years ago, I think it comes in. This witness is not on trial. So should all of it come in? Maybe not. Maybe more of a toned down version like, you've gotten into altercations for the Albert family in the past. Isn't that true? Maybe they tone it down and they give more of a vague overview and don't get into such specifics. I hate to say that I do see a lot of relevance in this for what the defense is accusing law enforcement of doing in this case and the similarities here. And it's a pattern of behavior from this police department potentially that they get involved in cases they shouldn't, and maybe they take things too far. Shy Gal, Peter, based on all the community support for Karen, do you think many other cases will be reopened? I have no idea. I think the answer is no, but I mean, defendants accuse cops of wrongdoing all the time. And that's the crappy part, is a lot of times it's not true. A lot of times it's BS. A lot of times it's people just grasping at straws. But they got a lot more in this case than your average case. Gail wins. Plus, no one is talking about all these guys drinking and driving, hypocrites. I do hate it. I agree with you. I thought about it too. It's like, and it seems like he let his girlfriend, Karen Reed, drive drunk. So he didn't drive drunk. I don't love that either. And it just seems to be, I don't know. But I agree with you. There's a lot of talk about, cops and others drinking and driving here like it's no big deal. But those are some of the charges that they brought. So maybe they are taking it seriously. So we'll see. McCrae, with all this apparent corruption, is there any chance this jury isn't bought and paid for? Just wondering. I have no idea. Somebody else said they think it would be cool if the jury had a lawyer. And it's like, yeah, that would be cool, but that's somebody that could be bought and paid for. So I don't know. It's wild. I'm interested to see how it all turns out. This is the beginning of a marathon, not a sprint. So let's remember that. John, will you put P-Hop's question up or comment? If only we had $1 for all the what the hell moments today we had today. I agree, P-Hop. Today was the most wild day to me for the information we got out and the connections. It feels like the defense has at least some of the goods that they were saying in opening statement, but there's a long way to go, like I said. And the state has the ball, and they got to score points. At least today, I will say, at least with the state today, did I not play that redirect? No, I did play that redirect. So at least the state with the cocktail glass, at least they tried to make some connections, saying we knew he came from Waterfall Bar, so the cocktail glass came from the bar clearly. At least they're trying to connect dots, right? I would like to hear them connect some more of the dots with the injuries in the car. And I think that's coming, but at least the state's trying to connect some dots, so we'll see. Kristen said, how do we get a membership? So there's two ways. The normal way is there is a join member underneath the video that you can do. I don't think it shows up on your phone. You click there and there are a bunch of different options. We have a whole video that explains the different tiers of memberships and different things you get that you can check out. Or way number two, because we have so many generous members that they're constantly gifting memberships throughout the lives. You have to be on the live. You have to have gifting turned off. I think earlier in this video, I put the step-by-step process up on how you have to do that. And you can be gifted a Lawyer membership to check out the perks that way. All right. That's it. We got to call it. Chad Daybell breakdown of today's videos. Also some wild moments there. Starting at 10 o'clock. If you guys are sticking around, it's going to automatically redirect you there. Make sure you like this video. Make sure you like that one. Let me know in the comments what you think of that video. I appreciate you guys so much. You are literally the best. Ashley said being a member is great. It's a lot of fun. We hang out a lot. We do some special stuff with the members. But that's all we got. That's it. I got to call it. It's late. I'm glad we started early. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.